Obscenity and indecency are specific legal terms which involve pornography, profanity, and other elements. And it's important to keep in mind that these terms cross boundaries in terms of the media. So let's take a look. In Roth versus the United States in 1957, it was determined that material is obscene if, to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to the prurient interests and is without any socially redeeming importance. And here's an example of another case where the U.S. Supreme Court tried to get at the issue of obscenity. The book Fanny Hill came before the court, and it was provided with a more narrow definition of obscenity, which included a three-element test that came to be known as the Roth Memoirs test. All three of the following elements must exist and be evaluated independently. So one, the dominant theme of the material taken as a whole must appeal to the prurient interest in sex. The material must be patently offensive by affronting contemporary or national standards. Here, it changes later on. And the material must be utterly without redeeming social value. Now, this may seem like a good test, but we have a whole lot of problems with definitions. And that's one of the problems with obscenity cases, and to a lesser extent indecency cases, is that it's difficult to come up with a real definition that works. In fact, one of the Supreme Court justices said, "I know obscenity when I see it." Well, that doesn't exactly work in a precise way for the law. In Miller v. California in 1973, there was a broader version and definition of obscenity. And this is the obscenity test that applies today. Okay? So Miller said that the first two standards below must be applied, and then a third standard was added in 1987. So the contemporary community standards against which a jury is to measure prurient interest and patent offensiveness are to be standards of the state or local. It changes from national community. And the utterly without redeeming social value element of the Roth test is replaced by the requirement that obscene works are those which, taken as a whole, do not have serious literary, artistic, political, or scientific value. Now, we've seen instances where some things have been deemed to have artistic value, which include excrement on religious artifacts, so that there's a lot of room in terms of getting away with obscene materials. In Miller, the third part of this is that juries must consider the impact on a reasonable person. Now, a reasonable person is something that you see a lot in the law. It's essentially somebody, you take somebody off of the street, put that person, in a courtroom, and that person is quote unquote reasonable. Okay, and again, we have it changed back from the local standards to national standards when assessing whether sexually explicit material has a serious value. So what happened early on is that people would take materials like Hustler magazine to court in Louisville, Kentucky, where the standards and the standards for the community taste was more conservative than those in New York, Los Angeles. So people went choosing courts based on more conservative standards to point out obscene materials and have them banned. Now, there are exceptions here. The government has a lesser burden and does not have to apply the Miller test before censoring or punishing publication of sexually explicit material if any one of the following circumstances can be applied. So that there is one issue which involves a court case, Ginsburg v. the United States, where there is commercial exploitation oftentimes of people under the age of 18. There is a distinction between those 18 and over and those under the age of 18. And if the mail is used for an unwanted assault of sexual material as described in Rowan v. the U.S. Post Office. So this used to be a standard that was used a great deal when something moved from a state and then used the post office to go across state lines. This standard was also used in mafia enterprises as well as extending the law to stop racism and discrimination. There's a lesser standard of variable obscenity that can be applied if juveniles are involved through the sale of adult magazines, which was the case in Ginsburg v. New York. Okay, so if this is confusing, it is. Okay, it's very difficult to nail down a standard when it comes to obscenity. Okay? So that in New York v. Ferber, there was the sale and purchase of child pornography, and what we find is that child pornography is banned outright. Okay, if you have it on your computer, you're going to jail. Right? And then we have what's called indecency, which is another legal term, which we'll delve into a bit later when we look at the difference between the law with respect to freedom of the press for print or text materials like newspapers and magazines versus radio and television. The standards are much tougher when it comes to radio programs and television programs. And in Pacifica v. the Federal Communications Commission, this is a very famous monologue by George Carlin called The 7 Dirty Words, and he said these dirty words over his radio broadcast. And the U.S. Supreme Court said that this was indecent. And the idea here was because the radio program could be automatically broadcast throughout the United States, it was very difficult to protect kids under the age of 18 from hearing it. And so therefore this very important restriction on freedom of speech still exists today. So that's essentially the legal side of obscenity and indecency. It's tough sledding in terms of banning pornographic and profane materials in the United States. So that's what we have for today. Thank you very much, and we'll see you online.